Welcome to Sakshi TV special immigration show with attorney Mr. Parvathaneni from Managing Attorney at law firm of Sim Parvathaneni and Brown. Please note that Sakshi TV now has 3 immigration shows every week on Tuesday at 5 p.m. EST with attorney Chan Parvathaneni, Wednesdays at 5:30 p.m. EST with attorney Prashanti Reddy in English, and on Friday at 6 p.m. EST with Banu and Indra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call us at 866-725-7441. Before we begin the show, please note that the information provided on this show is not legal advice and for general informational purposes only. Sakshi TV or its agents will not be responsible for use of information. If you need specific legal advice, please contact the attorney directly. Mr. Chan needs no introduction, but if you need consultation, please log on to spblawfirm.com for contact information. When you connect with them, don't forget to mention Sakshi TV. From the beginning, spblawfirm.com has put a wealth of free information and online tools in the hand of immigrant community and for the benefit of US employers. The www.spblawfirm.com site provides you with the latest and cutting-edge information on US immigration laws and policies explained in terms you do not have to be a lawyer to understand. So today's topic is various requests for evidence, RFEs, issues for the H1B filing after cap lottery and various immigration updates. We will continue the knowledge session along with the news and updates on the latest immigration followed by Q&A. Before we get into the topic, you can call us on the numbers on the screen for questions related to immigration and also ask tips. Hello Mr. Chan, before we get into this topic, do we have any specific latest immigration updates this week?
Hello Shivani, and thanks to all the dear Sakshi viewers for tuning in. So in terms of updates, the main updates are that the H1B lottery process finished last month, and the H1B cap filings. The cap filings refer to the H1B filings done for the first time. I mean, for somebody who has never been on H1 and somebody trying to get to H1. That is what we refer to as cap filings, and the cap filings are in full swing currently because the deadline started on April 1st and June 30th is the deadline, and most of the employers are trying to finish things as quickly as possible. Most of the employers are busy, and the cap filings are in full swing, and that's on the H1B side. And for the green cards, the visa bulletin based on the last month's bulletin, the dates moved up by almost 1 year. So it is very important that all I-485s are done as quickly as possible. Again, this month we are seeing a lot of I-485 filings for India after a long time. And the EB2 dates seem good, and we do not anticipate retrogression currently. But again, you never know. So anybody that is eligible should be filing their 485s, being as proactive as possible and get those done. That's pretty much about it in terms of the updates.
Yes. So Mr. Chan, the H1B lottery process has ended now. What are the next few steps in order to get the actual H1B approval?
First step is going through the registration process, which has happened last month. So everybody registered for the H1B lottery. Selections have happened, and now the employers and the beneficiaries know who has been selected. So that is step one. That is a very, very small step. Now is the big step, because the goal is to actually apply for H1 and get an approval. Without the approval, the lottery selection doesn't make any sense. So this is where the most critical thing needs to happen, which is filing the H1B petition appropriately, thoroughly, and ensuring that it gets an approval right up front without any issues down the line. So that is the goal. And how is that accomplished? So that is accomplished by employer and employee working in tandem very closely, making sure all the documents, either on the employer side or the employee side, are gathered and submitted to the right government organizations. And there are 2 important government organizations that are involved in this process. The very step in this process starts off with the employer filing the LCA. There is something called Labor Condition Application, or also known as LCA. This is a document that is filed by the employer with Department of Labor. This is very critical, and every H1B has to have a certified LCA. So the Department of Labor has to certify this LCA. there is no fees to apply for LCA. It is a free application that is done with Department of Labor. The whole purpose of this LCA, this labor condition application, is to notify Department of Labor where somebody will work. Because in US, if they're working in Dallas, the salary is different. If somebody is working in New York, the salary is different. If somebody is working in San Francisco, the salary is different. Which is why the employer has to notify Department of Labor where somebody is working, what occupation somebody is working in, what kind of a job it is. Is it a senior level role? Is it a junior level role? And so on. Because they have to state the appropriate wage levels for the job. So this is the information that they go to Department of Labor, and the employer attests that they will be paying the employee that particular wage. So this is a critical part that has to be submitted to Department of Labor, and Department of Labor will review this LCA and will certify the LCA. Once this LCA is certified, the next step is the employer takes this LCA and goes to USCIS and attests to USCIS that they will at least pay that minimum salary to the employee. And along with that, will submit all the information about their company, about the job position. Will also submit documents for the employee's credentials, their degree certificates, their mark sheets, their passport copies, and so on. And will file the petition with USCIS. So this is the step where the actual H1B petition, it is called the Form I-129. So this Form I-129 is drafted, and all the supporting documents are attached. And then this physical set, it is physically mailed to USCIS, either through FedEx or postal mail. But it is a physical filing. It is not an e-filing. It is a physical filing where the entire paper copies are submitted to USCIS. We don't have to submit any original copies. We can submit copies. So pretty much like the mark sheets, the degree copies, the passport, everything is a copy. So these copies get submitted to USCIS. And along with this physical copy, the employer also has to pay the fees. Depending on the size of the employer, the fees varies. If it is a small employer, less than 25 employees, the fees is always 1,710. If it is a very large employer and the employer is primarily dependent on H1B employees, the fees is 6,460. If it is a large company but not heavily dependent on H1B employees, the fees is only 2,460. So depending on the kind of employer, the fees varies, and it is anywhere between 1,710 to 6,460. The employer has to be very, very cautious. If the right fees is not paid, the entire package will be rejected and sent back. The employer cannot pay more fees than required. If the employer is supposed to pay only 2,460 and they pay more fees, the entire package will be rejected back. So this is where the employer is being very careful, and most of the time employers work with attorneys, and these are the things that are done carefully. Right fees is paid, right documents are included, and so on. And you go ahead and file this entire petition with USCIS. And once the petition is filed, one is just waiting for an approval, and then that's it. It is complete.
Yes. So, Mr. Chan, once the H1B filing is done, will it result in approval always?
So, typically, once the H1B filing is done and we pay the fees to USCIS, the government agency, we typically hope for an approval. We hope that we get a direct approval and we don't have any surprises. And in general, if everything is good, so the first thing that happens is USCIS issues a receipt notice. This receipt notice will have a receipt number, and it is like a tracking number. And USCIS will ask us to track this case while they're processing the case. And the case could take a month, 2 months, sometimes as long as 6 months. And normally what happens is during this process, they're reviewing the case. If they like everything, if they think everything is good, they will approve the case. If they think that they want some clarification, or they feel that some things are not in order, USCIS typically never directly denies the case. For a H1B, they cannot directly deny a case. What they do is they issue another notice, and they call this request for evidence. So this notice called request for evidence is issued by USCIS, and they tell the employer that they cannot approve the case yet, but they want some additional documentation, and they will take a decision once this additional documentation is submitted. And this notice is what is called as request for evidence, and also popularly called as RFE. So people typically hear this word a lot. An RFE has been issued, and what this means is request for evidence notice has been issued, and now USCIS wants more documentation before they will approve this case.
Yes. So, Mr. Chan, what exactly is request for evidence once the H1B is filed? Does request for evidence result in a denial, or do we have any statistics on how many cases get approved after getting the request for evidence?
Overall, what a request for evidence means is that USCIS is not satisfied with the filing, and they're not readily able to approve the case. So they're not approving the case, but they are giving us a chance to produce some additional documents that they require to get an approval. That's all request for evidence means. And all that means is it does not mean a mistake has been made in the filing. Maybe a mistake has been made, maybe a mistake has not been made. All it means is the USCIS officer has some issues raised, and they want some additional documentation to clear out those issues. So that's all it means. It means that we need to produce some additional documents. And the good news is that at least lately the denial rate for H1Bs is very low. Based on the statistics released by USCIS last year, we saw a 96% approval rate. And what that means is, even after the RFEs, not many cases get denied, and overall only 4% of the cases get denied. So that is a very, very low denial rate, at least last year. However, if you go back to the previous administration, past administration, to about 3 years back, we had as much as 23% denial rate. So it was almost 1 in every 4 cases getting denied during that time. So back then things were a little bad. The burden of proof was a lot different. But at least in the current times, in the most recent filings, the approval rate is very good, and the approval rate is very high. So more than likely, even if somebody gets an RFE, there is a very, very good chance that the case will get approved. And as of today, based on the most recent statistics, we are looking at about 96% approval rate across the board.
Yes. So, Mr. Chan, please let us know the most common requests for evidences that you see for the H1B filing.
I have been involved in over 2000 H1B filings in the last 1 year, and I had a chance to do some data analysis on what exactly is happening with majority of the filings. Majority of our filings, almost 99% of our filings in this 2000 H1B filings, we are seeing approvals. But the cases that are getting RFEs, we are seeing a pattern. And in general, most of the RFEs can be classified into 5 or 6 main buckets. So this is for the H1B filings. And typically, the officer is always looking for some very, very specific things. I'll talk about these 5 RFEs that we typically see. We very commonly see RFEs that are referred to as the Beneficiary Qualifications RFE. So most of the RFEs will target the beneficiary, and they will say the beneficiary does not qualify, prove that they qualify. So that's a very common RFE that we get. And the goal is to show that the beneficiary actually qualifies for the job. That is one RFE. And the second important RFE that we see is the Specialty Occupation RFE. So this RFE is basically asking us to prove that the job position is a very, very specialized position. So as a summary, that is what it means. And we see that quite often. We also see RFEs about the company information or the vibe check. And this RFE, all it wants is us to prove that the company is a legitimate company that is doing business in USA. So it is asking for company information. So that's an RFE that we see time to time. And another RFE we recently see quite a lot. I mean, probably I would say this is probably the number 1 RFE that we see lately, is regarding maintenance of status. So an RFE asking about maintenance of status is typically issued only if somebody is already in US. So if somebody is already in US, this RFE is issued, and it asks us to show that whoever is in US, they have not violated their current visa status and it will ask us to prove that their visa status is complied with, and it will ask us for a certain set of documents to prove that the employee is maintaining a valid status in the country, no visa violations in the country, and it will tell us to provide certain set of documents that are raised in the RFE. So that's also very common RFE. And for the cap filings, the most common RFE that we see is F1 maintenance of status. So when somebody is on F1, they typically are on OPT or CPT when the H1B filing gets filed. And when somebody is on OPT or CPT, typically it will ask us to prove that their OPT work status is valid or their CPT status is valid. It will ask us extensive documents about their F1, OPT, and CPT status. So that's another common RFE. And so I would say most of the RFEs fall in this bucket, but the uncommon RFEs, the other uncommon RFEs that we typically get are things like criminal history, if somebody has any arrest record in the past, or sometimes to do with the company employee count. Sometimes we get RFEs asking us to prove the number of employees in the company or the H1B dependency, because these things will impact the amount of fees they have to pay to USCIS. So sometimes, rarely we get these kind of RFEs asking for the employee count or the H1B dependency or the LCA wage level kind of issues. These are uncommon. So overall, I would say that majority of the RFEs, almost 95%, would fall in the categories that I just mentioned.
Yes. So, Mr. Chand, what are beneficiary qualification RFEs and how are these handled?
So a critical requirement for USCIS before they can approve a H1B petition is that the beneficiary should be qualified for the position by having an equivalent of at least a bachelor's or a higher degree in a very specific field that is required by the occupation. And what that means is that if we have an IT profession and one is supposed to work as a software developer, one is required to have an equivalent of at least a bachelor's degree or a higher degree in a specific specialty. So, for example, if we are applying for a software developer job, this RFE basically says, can you prove that your employee has at least a US equivalent degree in computer science, IT, or a closely related field? That is what pretty much the RFE would say. The reason we get this RFE is because somebody probably more than likely does not have an related degree. Say somebody has an MBA degree or a civil engineering degree or a mechanical engineering degree, and they are filing for an IT profession, like a software developer job. We more than likely will see this kind of an RFE. And the way to overcome this RFE is to show that the beneficiary is qualified. And luckily, we can use work experience and we can get an evaluation done to show that their work experience plus education is equivalent to a US bachelor's in computer science. So USCIS has a policy where they say that if we get an evaluation done by a US professor, so we have to go to a US professor, a professor that is a professor in an accredited university, and get an expert opinion from that professor. So if we can have a professor say that the experience is equivalent, we will be able to overcome this RFE. So what we normally do is we look at the education somebody has, try to get an evaluation done. If the education is not enough, we'll try to add the experience and try to get an evaluation done. And that is how we will try to overcome this RFE.
Yes. So, Mr. Chan, what are maintenance of status RFEs and how are these handled?
A maintenance of status RFE, it is issued only if somebody is already in US. Typically, if somebody is in India and we are filing H1B for a person in India, this RFE is never issued. But if somebody is in US, say either H4 status, H4 is basically a spouse of H1B employee, or say L1 status. L1 is somebody who is working for a company in US, or somebody on a visitor visa, B1, B2, because sometimes we have people on B1, B2 visitor visa also applying for H1B, or sometimes majority of the times on student status. Majority of the cap filings more than likely will be for F1 students who are trying to change their status. So when we have people in these kind of categories, what happens is USCIS, through this RFE, it will ask us to prove that their status is valid. So if somebody is in H4, the only way their H4 is valid is if their spouse, their spouse has to maintain a valid H1B status. Their spouse has to keep working in US. Only then their dependents are in valid status. So if you get a maintenance of status RFE for H1, H4 applicant, what we do is we say, okay, show us your marriage certificate, show us your spouse's H1B approval, show us your spouse's pay statements to prove that your spouse is maintaining valid status, which means that you automatically maintain valid status. That's how we prove for H4 people. Suppose if somebody is on student status, if somebody is on OPT. So as an OPT student, they are supposed to be employed. They cannot have unemployment once they cross a certain stage. So part of it is we going back to them and saying, did you have more than 150 days of unemployment during your 3-year OPT? Did you have more than 90 days unemployment during your 1-year OPT? Or did you have any violations? And so on. Or if somebody is on CPT, is CPT an integral part of your curriculum? Is the full course of study being maintained by you? And so on. Based on their visa status in the country, everybody has a certain set of requirements. We have to go back to USCIS and prove that they're maintaining a valid status. If somebody violates their status, they have problems, and that is what we try to argue, and we try to reply back to these kind of RFEs.
Yes. So, Mr. Chan, what are VIBE check RFEs, or else is it VIBE check RFEs, and how are these specifically handled?
So, USCIS has a database where they do a validation. So they do a validation of the business enterprise. So the business enterprise is basically the petitioner, the company. So this RFE says that USCIS, we try to do a validation of your business enterprise in our database, and we have not been able to corroborate the information that we have to what we are seeing in the file. For example, the number of employees, maybe the company's information, like their income, maybe the company's information, like their address, maybe whatever USCIS is seeing on their side, in their database, it is not matching, or there is some discrepancy with what has been filed with the H1B petition. So when this happens, USCIS comes back to us and says, okay, we want more information about your company. You prove that you are a valid entity. And when this happens, the burden of proof is that we have to demonstrate that the company is a legitimate company. The company is doing business in US. The company has business operations. And that the filing is in the regular course of the petitioner's business. So this is what we are supposed to prove, and it is very easy to prove. It is not difficult. So things like having a lease for the company, or a tax return for the company, the payroll documents showing the employees in the company and their pay statements, or the bank statements of the company showing various bank transactions, revenue for the company, expenses for the company, and so on. Various invoices for the services, because a company, it makes money. It makes money either through selling some IT services or through selling their IT products and so on. So do you have invoices? So if they have invoices, we show the invoices, the quarterly federal tax returns and so on. So through using a combination of these documents, it is very easy to prove the nature of the company, that the company is actively doing business in US, and go back to US and give USCIS the latest and the correct information about the company. And this RFE is a very easy RFE to get through in general.
Yes. So, Mr. Chan, what are OPT RFEs and how are these handled?
So, OPT RFEs are typically given if somebody is on F1 status and currently working on OPT status. And as a part of OPT, employees are supposed to work only in their field of study. They have some reporting requirements. They have to notify the school, and not only that, they cannot have unemployment that exceeds the mandatory set limits. So OPT is of two types. One is the initial 1-year OPT, and if somebody is in a STEM program, either science, technology, engineering, or math programs, they get 2 additional years of work authorization. So total of 3 years. So the rules say that yes, it is okay to have unemployment, but you cannot exceed 150 days. And whenever this RFE is issued, it typically boils down to going back and showing all the pay statements for the entire OPT period, and going back to USCIS and proving that they did not violate their unemployment requirements, and that they have been working in the field of study. So that is pretty much what OPT RFE refers to.
So, Mr. Chand, are there any other important issues raised in RFEs that you would like to discuss with us and our viewers?
So most of the time, the initial petition has to be as clean as possible. So in general, if the job duties are properly documented, if the project is properly documented, if the educational documents are all there, the I-20s for the students or the H4 documents, if somebody is on H4, these documents are documented and the filing is thorough, more than likely the RFEs are minimized. That being said, even if everything is there in the filing, sometimes because the officer sees things differently, they could raise an issue. So getting an RFA is not a big issue, but the biggest and the most important thing is if an RFE is issued, look at the deadline. Make sure you do not miss the deadline. Make sure one thoroughly reviews the RFE to see each and every issue raised in the RFE. And the minute the issues raised in the RFE are cleared, and the approval is almost guaranteed. So the biggest advice I would give anybody is, if you get an RFE, nothing to worry, look at the issues raised and make sure that you are providing the attorney the documents for each and every issue raised, work with the attorney, don't miss the deadlines. If that is done, the approval rate is very high nowadays, and people should be able to get an approval. And I would just say, good luck to everyone going through this process, so they have a successful H1B petition done and successful H1B approval.
Yes. Thank you, Mr. Chand, for coming on to our show. We discussed so many different topics here. And thank you for the viewers for tuning in. You're watching Sakshi TV with me, Shivani Raj.